Most people assume that if your name is on something, you own it. That assumption is exactly what regulators are trained to look past. There are two layers to ownership that the law treats very differently, and most people have never heard of either one. The first is legal ownership. Your name is on the title, the deed, the account, the contract. You're the one who shows up in the registry, the paperwork, the database. On paper, it looks clean. You're the owner. The second is beneficial ownership. Who actually controls the asset? Who receives the income? Who benefits when it grows? These two don't always match. That's where things get complicated. A property might be registered under a company, but the person pocketing the rent money is someone else entirely. A bank account might carry one name, but instructions on how to use it are coming from somewhere else. Legally, the account holder owns it. Beneficially, the picture is different. Regulators aren't confused by this. They've been watching this gap for a long time. In fact, the entire architecture of modern financial compliance is partly built around closing that gap. Anti-money laundering laws, know your customer requirements, beneficial ownership registries, these all exist because legal ownership alone stopped being trustworthy. When dirty money needs a home, it rarely stays in the name of the person who earned it. It moves through entities, holding companies, trusts, nominees, shell structures. Each layer adds distance between the beneficial owner and the visible record. From the outside, it looks like a legitimately owned business or asset. From the inside, the actual human being benefiting from it is buried several steps away. This isn't a new trick, but the regulatory response to it has gotten much sharper in recent years. After 2008, and then again through the 2010s, governments started realizing how much wealth was hiding in plain sight. Real estate in major cities, anonymous shell companies registered in low-scrutiny jurisdictions, accounts held in nominees, names, where the nominee signs papers but takes no real decisions. The money was technically owned by something, a company, a trust, a fund, but the person actually in control, often untraceable through normal channels. So regulators started requiring disclosure that went beyond the legal record. In the US, the Corporate Transparency Act, which came into force in 2024, requires many businesses to report their beneficial owners directly to a federal database. Not who the registered agent is, not which law firm set it up, who actually benefits from it. The EU has gone further with its AML directives. Many jurisdictions now require public or semi-public beneficial ownership registers. The threshold is usually something like 25% control or more, but in some frameworks it's lower. The logic is straightforward. If you benefit from an asset, you have to be findable. That's the regulatory concern in one sentence. Visibility, not punishment by default, just visibility. Because in financial crime, the separation of legal and beneficial ownership is often the entire mechanism. You can't sanction someone you can't find. You can't tax income you can't trace. You can't recover stolen assets if the ownership record points to a company that points to another company. The gap between legal and beneficial ownership is, in many cases, the answer to how financial wrongdoing persists. But here's something that often gets missed. This isn't only about crime. Beneficial ownership rules also affect perfectly ordinary business structures. Family offices, holding companies, real estate investment vehicles, estate planning trusts. If you're a shareholder in a company that owns property, for example, the underlying ownership question becomes relevant. Who controls the entity? Who receives distributions? Who makes the decisions? These aren't illegal arrangements, but they still fall under the disclosure requirements in many jurisdictions. The assumption that compliance is only for criminals is itself a costly mistake. A lot of legitimate businesses got caught flat-footed by the Corporate Transparency Act specifically because of that assumption. Missed deadlines, penalties, compliance costs that showed up as a surprise, not because they were hiding anything, because they didn't realize the rules now applied to them. That distinction matters. Disclosure requirements don't imply wrongdoing. They imply scrutiny. And scrutiny, in modern finance, is applied broadly, not just to suspicious transactions or flagged accounts. The baseline assumption regulators now operate from is that structure can obscure ownership, and that obscuring ownership creates risk. Risk of tax evasion, risk of sanctions violations, risk of money being moved on behalf of people who shouldn't be moving it. So when a bank asks for beneficial ownership information during account opening, that's not bureaucratic noise. That's the institution protecting itself from being used as a conduit for something it can't see. Financial institutions face serious penalties if they facilitate transactions for beneficial owners they failed to identify. So the due diligence isn't optional. It's built into their own liability structure. And the more complex the ownership structure, the more documentation gets requested. A simple sole proprietorship? Straightforward. A layered holding company with foreign shareholders? That's a different conversation. Compliance teams will trace the chain until they find a human being, an actual natural person, who qualifies as the beneficial owner. That's the phrase regulators use, natural person, as opposed to a company, a trust, or a legal fiction, because money ultimately flows to people, not to entities. Entities are just arrangements. The entity might own the building, but someone, somewhere, receives the value when that building performs. And that someone is who the regulator wants to know about. Trusts are one of the more nuanced areas here, because trust law deliberately separates control from benefit. The trustee holds legal title, the beneficiary receives the economic benefit, the settlor created the arrangement. 3 different roles, often 3 different people, sometimes more. From a legal ownership perspective, the trustee is the owner. From a beneficial ownership perspective, it's the beneficiary. Regulators now require disclosure of all 3 roles in many jurisdictions, because each one represents a different kind of influence over the asset. This is exactly the kind of structural complexity that makes financial crime investigators' work difficult. And it's also why estate planning attorneys and compliance officers now work in much closer coordination than they did 10 years ago. Legitimate planning still happens, but it now happens with documentation that can withstand scrutiny. A trust set up for genuine estate planning purposes doesn't disappear from regulatory view. It gets registered, reported, disclosed. The privacy that trusts once provided has narrowed considerably in most developed jurisdictions. That shift has been uncomfortable for some. For others, particularly those using structures for legitimate generational wealth transfer, it's simply a new compliance layer. Either way, ignoring it is not a viable option anymore. Now, none of this means that having a holding company or a multi-entity structure is suspicious. Most medium-sized businesses operate through multiple legal entities for completely sensible operational and tax reasons. Liability separation, operational clarity, different asset classes under different entities. These are ordinary business decisions. But ordinary business decisions now come with a disclosure obligation attached. If you're a beneficial owner of a qualifying entity, you may have a legal duty to report that to the relevant authority. In the US, that means filing with FinCEN. In the UK, that means appearing on the Persons of Significant Control Register. Failure to comply doesn't just create a fine. In some cases, it creates criminal exposure. That's the part that surprises people who think of this as an administrative formality. The regulatory intent is to make beneficial ownership a matter of record, not just legal ownership. And increasingly, that record is being cross-referenced across databases, jurisdictions, and financial institutions. A beneficial owner who appears in one country's register but not another's can trigger a flag during a transaction. It doesn't mean wrongdoing, but it creates friction, it creates delays, it creates questions. For businesses operating internationally, the coordination of beneficial ownership disclosures across multiple jurisdictions is now a live compliance task. Not a one-time filing, an ongoing obligation that changes when ownership changes. If shares transfer, if a trust beneficiary changes, if control of an entity shifts, those changes often need to be reported. Ownership is not a static fact anymore, it's a tracked, reportable, updatable status. The practical takeaway here is simple. The gap between who legally owns something and who actually benefits from it is no longer a private matter in most regulated environments. If you control an entity, receive income from it, or direct how it operates, that may make you a beneficial owner in regulatory terms, regardless of what the legal title says. Understanding which side of that line you're on isn't optional. It's a baseline requirement in modern finance. The question worth sitting with: if someone traced the structure around your assets or business interests today, would the beneficial ownership picture be clearly documented and compliant, or would it need work?